Yeah, that's fine.
Oh, yeah. Just in case I'm looking. Thanks. This is some raining. Court rise. Application and appeal in the matter of OCM Maritime Nile LLC and another, and Current Shipping Co. and others.
Yes, Mr. Bartley.
Yes, may it please you, my lords. In this matter, I appear on behalf of the appellants and my learned friend, together with my learned friend, Miss Claudia Wilmot-Smith of Counsel, and my learned friend, Mr. Robert Bright, Queen's Counsel, appears with Mr. Charles Holroyd of Counsel on behalf of the respondents. My lords, this is an appeal against the order of Sir Andrew Smith, sitting as a judge of the High Court. His order, that was dated the 4th of March 2022, and it followed a trial. And by that order, he directed the first appellant to surrender possession of the vessel, the Courage. The judge also found that the first respondent had been entitled since the 28th of July 2021 to possession of the Courage, and that the second respondent had been entitled to take possession of another vessel, the Amethyst, on the 1st of September 2021. The judge found, although it wasn't an issue, that the relevant charter parties with which we are concerned had been terminated by notices on the 18th of June 2021. The issue in the court below and the issue before your lordships has to do with two matters. First, whether or not there was a right to possess under the terms of the charter party following the termination, and secondly, a second issue as to the equity of relief and forfeiture. The judge in the court below adjourned the respondents' claims for damages and other financial relief, and he refused the respondents' application for relief from forfeiture. So the appellant's application for relief from forfeiture. I'm grateful. The judge also refused permission to appeal, but permission was granted on the 13th of May of this year by Lord Justice Snowden on the basis that the grounds of appeal had a realistic prospect of success. There is effectively one core bundle that has been filed, and from the perspective of the appellants, there is no need to look beyond that core bundle. The judge's reasoned judgment sets out in detail the background and information, and I'll be taking your lordships to that judgment in a moment. Reynolds will have noted that both the appellants and the respondents are entities that are registered in the Marshall Islands. In my skeleton argument for the appeal, in the appeal skeleton argument, at paragraph 4, I stated on instructions that the appellants were until recently under the control of Abdul Jalil Mallah, a Syrian national resident in Greece or possibly Sweden. My lords will know that Mr Mallah featured in the court below because...
I wonder whether we can take this more shortly. Are you building up to the question of the supplemental bundle?
Yes.
Well, we have obviously seen the recent exchanges about this. Your position is that you are not attempting in any way to go behind the position before the judge. The only reason why the respondents want the skeleton, want the supplemental bundle in is that they think you may be and want to show that you're wrong. And if that is indeed your position, and if you don't stray from it, at the moment, I don't see any reason why we should look at the supplemental bundle. We have, as we said we would, looked at it de bene esse, and I must say in my case that means looked at it, not read it through. I've seen the sort of material it contains, but I haven't digested it. My lords may have been more diligent. But we really don't think there's a problem about this. If Mr Bright, having heard your submissions, wishes to refer us to the bundle and persuades us it's relevant, we will look at it. And if not, not.
I'm very grateful for that indication.
Okay.
And as I've said in the note which I submitted to the two lordships, the appellants are bound by the judge's findings as to Mr Mallah's control.
Yes. Well, you've said that, as you said. Yeah.
And we're not seeking to deduce any evidence.
No, well, that's helpful. Thank
The
you.
trial took place over 5 days. It was heard, I think, remotely, and there was no evidence of fact called by the appellants. There was expert evidence called by each of the parties, but the judge found there wasn't much between the experts, and it's not something that features on this appeal. The judge, having reserved judgment, then handed down his judgment, in which he found that the charter parties having been terminated, that the respondents were entitled to take to possession of the vessels. And it follows from that the appellants had in effect lost their rights to exercise their options to purchase, which would otherwise have been available under the charter parties. In his judgment, the judge dealt with the 3 issues that were being advanced on behalf of the appellants in the court below. The appellants, and it's worth identifying this to close this issue down, the appellants had, by the time of the trial, certainly admitted that events of default had occurred.
Yes.
And they didn't dispute the notice of termination of the 18th of June and the entitlement to terminate. The 3 areas of dispute was, first of all, the construction issue as to the meaning and effect of Clause 46 of the Charter Parties, which provided a mechanism for obtaining possession after termination, and whether those remedies were, in one sense, cumulative, whether they were independent of a more general clause at Clause 29 in relation to repossession, and whether or not the provision of a notice, a specific notice under subclause 46A Roman 1, was necessary prerequisite for that notice to have been served and for there then to be non-payment. That, in a sense, was the construction issue. The second issue was a submission that the issue of the loss of the purchase option within clause 48 of the charter party constituted a penalty, and that penalty issue was disposed of by the judge on the basis that it didn't actually qualify as a penalty having regard to the Supreme Court's position in Macadasian, which is well known now. And then the third point was the issue of relief from forfeiture, which has to be seen as an alternative submission to the construction issue. The judgment is going to refers to certain contractual documents, and I just want to take my lords briefly through those documents before we look at the judgment. And the documents that we'll be looking at is, first of all, a document which was described sometimes as an offer of finance or finance agreement or term sheet, but the judge describes it as effectively an agreement between the Oryx entities and the controllers of the respondents to provide finance or part finance for the purchase of vessels.
Just before we get into the detail, Mr. Barkley, you spoke to Mr. Bright about timing. So, or if you haven't, in any event, we perhaps ought to just ensure that you will, in practice, I imagine, make the substance of your submissions this morning.
Yes, I would intend to complete my submissions in the morning.
Yes, that's what I would expect, but I just thought I should just confirm that was the case.
Yes.
And we have, of course, you're quite right to take us to the key documents, but we have obviously all read the very thorough judgment with care, so where we want to find a lot of the material and the issues defined. So no doubt you will bear that in mind.
Well, I will, and I'll try and deal with it economically.
Yes, of course. No, that's fine. I just thought I'd say that before you got in.
I'm very grateful. So, my lords, if I can take my lords first to page 146 in the core bundle. Well, this is the finance agreement referred to in the judgment. It's come from Meerbaum Capital Solutions, Inc., which, on the evidence the judge found, was an advisor of Oaktree, describes it in the judgment as Oaktree's advisor, and it sets out terms for the financing, as you will see from the reference in the opening paragraph, discussions on your behalf in receiving an offer for bareboat hire purchase financing of the vehicles or the vessels to be acquired, and if this is acceptable, endorse your agreement. And it was signed, as you can see at page 156, by Mr. Mallah on behalf of the charterer. And the judge refers to that, therefore, as being effectively an agreement. And it describes a structure, and again, I'll deal with this, if I may, hopefully efficiently. The purpose is identified at the bottom of page 146, which is to provide part financing for acquisition of the vessels. And this is going to be a recurring theme of our submissions, that as far as the respondents are concerned, their interest was only in the money. They weren't in the business of shipping. Their offices were in California. They set up the special purpose vehicles in order to enter into the charter parties. But I'll develop their submissions further. But I just draw your attention to the fact that the purpose is clearly described as being financing for the acquisition of the vessels. And indeed, Oaktree Maritime Finance is described at Clause 2 as the investor, with Meerbaum as the investor's advisor. The finance amount at this stage, which was being made available, was £13.5 million, $13 million, I should say, US dollars, and in fact, by reference to the two ships that were ultimately purchased, the amount advanced effectively by the respondent was $4,250,000 and $5,300,000 US dollars, respectively, for Courage and Amethyst, with the against what was paid by the Appellants, which constituted, in terms of the price, getting on for 50%.
Sorry, what figure did you give just now? I just didn't hear it.
I beg your pardon?
What figure did you give just then? I didn't hear it.
Yes. Well, what I can do.
No, just give me the figure. I just didn't hear it.
So I'll take.
You mentioned the figure. For
yes.
The total
So Courage was purchased in November 2000.
No, you just said 4 million for Courage plus 5 million Amethyst, and then you said as against some figure contributed by your clients.
Yes. So $4,171,764 in relation to Courage.
Mr. Bartley, sorry, I've got those figures. I thought you said...
You said getting on for 50%.
Yes.
And then, thank you, I just didn't hear that.
So I'm terribly sorry.
Okay, you contributed roughly another 50%.
Exactly.
Thank you.
I'm grateful. And the mechanism was going to be using a charter, and the charter there is identified, the former charter is identified at Clause 13 as a Hell or High Water bareboat charter incorporating back on 2001 terms.
I know what a bareboat charter is, but what's a Hell or High Water bareboat charter?
Right, well, as I understood it, and it's reflected in that the charter has to pay irrespective of what happens to the vessel. The vessel would otherwise be a frustration, or otherwise be destroy the subject matter. But you, as I understand, you still have to pay.
Thank you. Which I suppose makes sense with the finance arrangement.
Exactly. It is relevant to the submissions in relation to how we're going to construe the terms. I just want to, again, just take this briefly because these are all eventually replaced by the actual contractual documents between the individual parties to the charter party. But the charter party there is identified as 25 months from delivery. It's a relatively short term. We can see that that the fixed charter hire is really the finance amount divided by the term. So if it's 24 months or 25 months, then the first installment is 0, and then you have the installments divided by 24, the subsequent installments. And we can see that's the fixed charter hire. There is there's a definition of outstanding principal at page 149, which is the finance amount minus the aggregate fixed charter hire, because effectively the charter is repaying the principal sum. So by repaying the principal sum, the outstanding principal is reduced, and it's reduced pro rata with the payment of the fixed charter hire. And again, if I can make this point in passing, there's no suggestion that the charter hire costs have anything to do with the market value of the use of this type of container ship. So the bulk carrier, there's no suggestion, I don't think it was ever made in the court below, certainly no evidence suggested, but all the evidence points in the fact that this is a mechanism for the purchase of the ships.
The judge so found, didn't he?
Yeah, yeah.
Is this, was there evidence that this is a common form of financing the purchase of bulk carriers or indeed other forms of vessels?
I'm not aware that there was any evidence directly. There's nothing in the judgment to suggest that the judge was saying that this was either ubiquitous or unusual, as the case may be. What the judge, when it comes to the issue of construction, my lord is absolutely right that the judge did identify the specific character of this arrangement, which was, we say, akin in the nature of effectively the financing of purchase financing.
I mean, it's sort of hire purchase, really.
Yeah.
It is a half.
It's actually called hire purchase in the first sentence of the letter.
Well, yes.
I mean, you're making of course, it's terribly important to your case, Mr. Barclay, but you are making a bit of a meal of it. I don't think it's ever been disputed that that's the character.
Yeah.
But nevertheless,
indeed.
Your problem is it had particular terms,
yes.
And the judge says that if you do it in the form of a charter, you will find yourself with terms that are commonly encountered in a charter, in a charter party.
Indeed. So my lords will recall that the Beacon pro forma document that was initially produced did have a hire purchase component expressed as hire purchase, which was then substituted by deletion by rider clauses, which we'll look at.
We will resist the temptation to debate the points until we've seen all the documents.
I'm grateful. I'm grateful.
But obviously, I see why you're emphasising these points.
My lord, can I? The second component of this arrangement was to return interest as well. So that's described as variable charter hire at clause 20 in this document, and it is effectively 7.5% over 1 month LIBOR. And then if I can just draw attention at page 150 to the purchase option, because there's a purchase option which is at the to purchase subject to payment of all outstanding payments. The charterer can terminate and then purchase, and there's a slight marginal increase there. And then there is a purchase obligation at clause 26 or paragraph 26, where the charterer is said to have an obligation to purchase on the last day of the charter at the option price. Again, I needn't spend a lot of time on this, but we can see that the option price represents really the amounts that are outstanding in terms of the principal sum at the time, with some adjustments. So that's the first of the documents that I wanted to invite attention to. The second document is the actual memorandum of agreement whereby the carriage is purchased. Now, my lords, my learned friend again takes issue with, which I think is a semantic point in relation to the skeleton in terms of when I talk about the purchasing of the vessels by the appellants. The position is that the memorandum of agreement we're looking at page 157 is a document that is signed by Mr Mallah on behalf of Oryx Shipping. It is in relation to a vessel, Ikan Joan, which becomes the Courage, and it provides for the purchase for the price of £8.5 million, $500 million. And we've already identified that that the appellants provide approximately 50% of that. I don't think it's necessary to look at any of the specific terms attached to the memorandum of agreement, other than to point out that the agreement is clearly an agreement entered into with Oryx and not with the respondents. And then we come ultimately to the charter itself at page 167. I don't need to trouble you with the contractual documents, the memorandum of agreement in relation to the sale of the Amethyst and the subsequent charter party in relation to the Amethyst, because the issues are common to both. I don't think that anything in relation to the Amethyst that I specifically need to draw to your Lordship's attention. So, starting at the frontiers at page 167, you'll see that the parties to this charter party are the first respondent and the first appellant, and relates to the vessel which by now is called Courage. My own friends will want me to refer to this. I do. You'll see that there are some there's some references to the specific clauses which were modified by this frontiers, and perhaps the relevant one that my own friend will want me to draw attention to is box 20, which places certain restrictions called trading limits, which have to be read in conjunction with a clause 6. The charter period is 25 months or 60 months of the charter's option, and other than that, there's nothing else that I specifically want to draw the attention of the court to in terms of those boxes. You can see the execution of the agreement at page 169.
You made the point that it was Oryx who purchased the vessel under the MOA.
Yes.
So what do you say is the mechanism by which OCM became the owners in a position to demise charter it to you?
I think the evidence was, and it is referred to in the judgment, was that both Oryx and indeed the OCM parent were going to use SPVs, special purpose companies, in the Marshall Islands to effectively become the parties to the charter.
Yes, well, that's OCM Maritime Nile LLC.
Yes.
So did that company acquire title to the vessel from Oryx, or how did title get to it?
Well, so the position is that it was always acknowledged, and indeed, generally speaking, the party in the position of my clients would be stopped from denying it. The title that the respondents who were chartering the vehicle, the vessels to them under the charter parties, were the owners.
Could I attempt an answer?
Yeah, and my learned gentleman reminds me that the evidence, I think, was that they'd been nominated presumably by they've been nominated presumably by the Oak Tree Capital Management. Yes. And similarly, although the privity of contract in relation to the memorandum of sale was between Oryx and the original seller, Oryx nominated the OCM entities to effectively take title.
So under the memorandum of agreement, the buyer was named as Oryx or its guaranteed nominee.
Yes.
And you say, well, Oryx nominated this entity to take title.
Yes, that's my understanding. So and so we now turn to the terms, which are an amalgam of what may be called the standard terms and terms that have been modified either by deletion or addition or by reference to rider, a significant number of rider clauses. And if I can just take Malah's through what I think may be relevant of these, clause 6 is referred to by the respondents. These are the trading restrictions, which I showed you in box 20, that there were certain restrictions and the vessel had to be employed in lawful trades within the trading limits indicated in box 20. I also draw attention to clause 2A, that drawing the chart.
It can't be 2A.
Sorry, clause 10A, page 171.
Yep.
And 10A, Roman 1. And again, it's a point we've made that during the charter period, the vessel shall be in the full possession and at the absolute disposal for all purposes of the charterers and under their complete control in every respect, and the charterers shall maintain the vessel, her machinery, boilers, etc. in good state, in efficient operating condition, in accordance with good commercial maintenance. And similarly, if one goes to the second column at letter B, 10B, the charterer operation headed the hebendum operation of the vessel, the charterers shall at their own expense and by their own procurement man, victual, navigate, etc. the vessel during the charter period and pay all charges, etc., etc. So this, you might think, is what you would expect to see. The charterers effectively are responsible for maintenance.
Well, we just say see what it says. You need to tell us.
Yes. Yeah. And then, if I can draw attention to clause 11A, page 172, there is the obligation of charterers to pay hire punctually in accordance with the terms of this charter, in respect of which time should be of the assets. And there's a cross-references to some rider clauses, further clauses which we'll look at. And delay in payment, if I can just show 11F, delay in payment shall entitle the owners to interest at the contractual rate. Clause 13A, again, is relied upon by the respondents that during the charter period, the vessel should be kept insured by the charterers at their own expense. And then at 17A, so clause 15, yes. And at clause 15, there, I draw attention to that at the expiration of the charter period, the vessel should be redelivered by the charterers to the owners, and I think that's probably all I need to read present purposes. And then clause 17, the indemnity, the charterer shall indemnify the owners against any loss, damage or expense incurred in relation to the operation of the vessel. That includes arrest. And then I come to clause 28. And we're now coming within the territory really of the matters that we say are critical. So, first of all, clause 28A provides for a right to terminate by written notice. So the owner shall be entitled to withdraw the vessel from the service of the charterers and terminate the charter with immediate effect by written notice of the charterer if the charterer fails to pay hire in accordance with the provisions of this charter. Roman 2 deals with the two clauses I took you to, clause 6, trading restrictions, 13A, insurance, and clause 28A, Roman 3, I don't think has any significant application in this case, but just draw attention to it if there's a failure to rectify notified requirements. And then 28E, bottom of page 175, the termination of this charter shall be without prejudice to all rights accrued due between the parties prior to the date of termination and to any claim that either party might have. And just stopping me for a moment, so that insofar as it may be relevant, I would say that the preservation of rights in this case has to be looked at, looking at the agreement as a whole, and could also incorporate and include the equity of relief from forfeiture.
But that's not in dispute, is it?
No, it's not in dispute that the equity arises. The point in dispute was the exercise
Right.
of the discretion. And then, my lords, we come to clause 29.
Sorry, clause
29,
29.
top of page
Yeah, no, I just didn't hear what you
176.
said.
This was so that in the event of the termination of this charter in accordance with applicable provisions of this charter, the owners shall have the right to repossess the vessel from the charterers, and one can see that it goes on to say that the charterers will hold the vessel as bailee only and continue to maintain class and insure the vessels as required by the terms of this charter, notwithstanding the termination of the chartering of the vessel. And my lord, it's likely that the reference there to the deletion of gratuitous bailee and the obligations to continue to perform certain requirements under the charter was done deliberately in order to pass on continued obligations which wouldn't otherwise apply in the event of a repossession. Can I now come to, as my lords noted, page 179, one has the hire purchase agreement in its standard form, which has been deleted.
I suppose that indicates that it's by no means unknown for these agreements to be used as hire purchase agreements.
Yes, yes. And yeah, it's not an. acknowledge that. I think there are specific features in this case that differentiate it from the standard. And one of the differences here is not merely the option to purchase, but the obligation to purchase. We'll see that. So looking at page 184, we're looking at page 184 at clause 34A. There's an obligation to pay the charter hire on each hire payment date in the amount equal to the aggregate of the fixed hire, which we saw before is effectively capital, and the variable hire for that period, which is effectively the interest. And if one needed to go to it, those are defined terms which appear page 237 and 244. But they clearly are linked, we say, as we saw previously in the purchase, in the financing arrangement, to a distinction between the capital advanced and the 7% above LIBOR interest payment. And that is, if anything, reinforced by subclause C at the top of page 185, that the fixed hire is deemed to have been applied on receipt by the owners towards reducing the outstanding principal. Again, a defined term, page 240, which is effectively the balance then standing of the capital advanced by the respondent. And we can see that at E we saw the references to the hell and high water basis, and this spells it out within the sub-clauses of paragraph E, because effectively the charterer continues to bear the risk and to pay the charter hire irrespective of those circumstances. And the matter is made even more explicitly at subparagraph letter F, page 186, that the obligations of the charterer under this clause survive any frustration, save for very limited circumstances where it's as a result of the sole fault of the owners, etc. I'll move on now to the events of default provisions, and they can be found page 220 at clause 45. And so there's a number of events that are treated as event of default for the purposes of the Charter, starting with, at letter A, non-payment. So, non-payment on the due date of any amount payable without it being remedied within 3 banking days, in the case of administrative error, is an event of default. There are a number of other events. Perhaps I should just draw attention to letter D, the case of misrepresentation. There's also in letter P, page 223, arrest of the vessel, and then Q probably isn't relevant, and then we come to the owners, there's insurance at letter R, change of ownership at letter S, and then there are the owner's rights, which lie at the heart of the construction issue, which we see at page 224 with clause 46. So it provides that at any time after any circumstances described as events of default have occurred and are continuing, the owners may, by notice to the charterers, specify, terminate the chartering by the charterers of the vessel, whereupon the owners may, at their option, but with no obligation to do so, Roman 1, declare by notice given to the charterers the aggregate amount of the then outstanding principal and the indemnity sum to be immediately due and payable, whereupon the same should become immediately due and payable, and the charterers should be obliged to pay the actual balance of the same to the owner, together with the default interest, which is the 35D interest, and the applicable premium payable under 34(1)A, as if the principal sum, outstanding principal, was being prepaid. So there's a prepayment penalty as well on the date of the owner's notice. So the effect of that notice, we say, is to calculate, aggregate, and identify to the charterers precisely what it is that the owners would expect to receive on full performance of this agreement, because what they're getting is the outstanding principal, they're getting the interest, they're getting the accelerated receipt penalty, and they are receiving that, we say, which is effectively their interest, their legitimate interest, so far as having an interest in the money is concerned, would be, we say, satisfied, clearly would be satisfied, were that notice to be complied with by payment. When we look at the judgment, and when I come to criticize the analysis made by the learned judge, he took the view that the requirement for the notice didn't feed into the other requirements or the other remedies that are available under 46A. Now that cannot be right, because when one looks at, first of all, Roman 2 is the right of the owner to take action to collect the full amount as mentioned in that notice. So clearly, although it doesn't specifically state so clearly, the only way in which that can be understood and be given any form of effect is that is dependent entirely upon the giving of the notice. And then if we look at the clauses at Roman 3, 4, and 5, here we say it's even clearer. I mean, in the case of Roman 2, it has to be the case, because otherwise it would be meaningless. But in the case of 3, 4, and 5, each of these remedies that are being contractually made available to the owner are predicated upon two things: the giving of the notice and the failure of the charterers to pay the full amount mentioned in the notice. And that unlocks for the owner a number of remedies: to retake the vessel at Roman 3, Roman 4 to declare that the vessel be redelivered, and Roman 5 significantly, unless the amount, which is effectively, we say, the calculated financial interest of the respondents is paid, then with or without taking possession, the owners can sell or dispose of the vessel. I also, whilst we are at this page, just draw attention to B, because although it's some removed in distance from the more general clause that we saw at clause 29, it is referred to in the next clause B, because it's provided that if the owners repossess the vessel as contemplated by clauses 29 and 46A, the owner shall be entitled, etc., etc. And I just say that there is some significance to the use of the conjunctive there to indicate that the parties should be taken objectively to have regarded repossession as being a combination of rights under 29 and 46A in conjunction. And then taking, my lords, to subparagraph D at page 226, some lines was placed on this by the respondents, but in my submission doesn't take them very far. No remedy referred to in this clause, which has the habendum owner's rights, which again, although a habendum is not necessarily conclusive or a guide so to interpretation, we do say it is relevant that it is expressed in those terms. The no remedy referred to in this clause is intended to be exclusive, but each shall be cumulative. And there's nothing to prevent more than one remedy being used simultaneously or later. But it doesn't take my submission take the response any further in this respect, because it's always predicated on the giving of the notice and the failure of the charterer to comply with that notice by making payment in full. And then we say that F is relevant. Subclause F, that the owners and the charterers each agree that the payment of the outstanding principal and the indemnity sum, as set out in 46A, is a reasonable pre-estimate of the damages that will be suffered by the owners arising from the termination of the chartering of the vessel and represent liquidated damages and not a penalty. We say that also is significant, because first of all it anchors 46A in relation to termination, but also because it demonstrates that, once again, it demonstrates eloquently that the legitimate interest of the respondents is to get back their money and their profit. That's the investment they've made. And they've agreed, the parties have agreed by this, that receiving the 46A1 sum as calculated by the respondents really compensates the owners for the termination. And And G, in my submission, is also relevant because, again, it demonstrates in my submission that the only way to read this part of the agreement at 46 is to see it as putting a contractual fetter, a restriction on what otherwise might have been broader rights available under the agreement or under a standard form. So clearly, that we can see that the mechanisms to look after the legitimate interests of the two parties, they have expressed them in objective language. They've expressed them in what we say are terms that are clearly intended to qualify and cut down a broader right of possession. And then, if I can take to the purchase option and obligation, I'll do this hopefully without taking too long. We've already seen that there's a option to purchase, and that's not unusual, equivalent to a hire purchase. But there's also an obligation to purchase, which you can see there just below the center page. If the charterers have not exercised their purchase option before the final option date, then they must purchase the vessel for the purchase obligation price, which again is defined as the residuum. The date of completion should be the date of final option date. So it's got characteristics of hire purchase, possibly could be seen more akin to a conditional sale, since the purpose is ultimately for the title to pass to the charterer. Just stopping there at this point and just say that from the perspective of the parties, whether you look at it in terms of what they might subjectively consider position, or more importantly, how objectively it would be viewed using the appropriate canons of construction, the idea that the owners could get back all their money and also take the vessel at its full capital value when 50% of it had been provided by the person seeking the finance is an absurdity. It would be something which would be completely uncommercial. I don't think that is what the respondents themselves would contend for. And this will be relevant to the criticism that we make of the judge, because the judge, I'm sure, had in mind, but he didn't specifically refer to any of the authorities relating to the approach to iterative interpretation. But clearly, when looking at this, the judge had to consider the contract as a whole, and I'll make my submissions when we come in the context of the judgment itself.
Well, he said in terms he was considering the contract as a whole, and he clearly was.
Well, what he
thought it meant something different from what you thought it meant.
Well, yes, but I don't think that it's necessary before this tribunal to take my lords to Woods and Capita or any of the authorities which are now very well established. And I mean, what the judge's function was to construe and interpret a contract where there were rival interpretations, as he acknowledged, and again, it's trite that the court's task, and his task, was to ascertain the objective meaning of the language in which the parties had chosen in which to express their agreement, and that's what I know that my lords will be doing. And he had to look at it, consider what a reasonable person with the relevant background knowledge, including the finance agreement that the judge referred to, would consider at the time what would at the time of the how the contract would have been understood by the parties at the time of the contract. And yes, the court does have to look at the contract as a whole. And in this case, where there are at least two possible constructions, the court had to not only consider business common sense, but it had to be a unitary exercise which involved that iterative process, which means you check each of the provisions of the contract and consider what the commercial consequences are. And this I say was not was where the judge erred, and where this court will come to a different conclusion. Can I, before leaving the charter party, can I draw attention to clause 51, which in my submission should have been given more prominence by the judge. So, although the judge found, which is undoubtedly the case, that the standard form provisions, including clause 29, had been amended, you can see from clause 51 that the parties at the time of the contract gave priority and prominence to the rider clauses, and in particular those 32 to 59. So insofar as it may be said to be any inconsistency as opposed to a qualification or a gloss between the provisions at 46 and the provisions at clause 29, the parties' own agreement gave priority to the clause at 46, the definition of owner's rights. And my lords, I took my lords briefly to the clause 48 provisions, which is the right and obligation to purchase. It featured differently in the court below because that was really the point at which what was being alleged was penalty, and the loss of that right was regarded as being entirely disproportionate and amounted to going well beyond the legitimate interests of the owners. Now, the judge had a lot of sympathy with that argument, and when he was dealing with the issue of penalty, although he came to the right conclusion that the clause didn't amount to penalty, in that part of his judgment, he takes trouble to actually identify this the harshness of this provision and its effect upon the charterers. But what he fails to do is to consider that the very same harshness and the very same effect would apply if the respondents' interpretation was to be upheld. So their rival interpretation would put the charterer in a position where they would suffer very similar consequences.
You say it follows from the interpretation. I'm not quite sure why this has much to do with the interpretation question.
It has to do, my lords, with the question of what the commercial consequences would be.
Well, that's
when looking at two rival interpretations, and as to whether as to whether Clause 29 is freestanding, whether there's a requirement to serve a 48.1 notice, whether compliance with that notice takes away the right to recover possession. The consequences of the respondents' interpretation is to produce a result that is extremely catastrophic for the charterer.
Well, that's true of yours too, isn't it? I mean, on the basis of your case, the owner serves a notice and can then do all these things. That's just as catastrophic.
Well, not if the owner complies with the notice.
But in the case of an event of default of the character that occurred here, how could they?
The notice only doesn't require them to remedy anything other than to pay the calculated sum. It's all about money. It puts a stop to the other remedies immediately upon payment of the money. So the parties don't enter into a contract on the basis they're not going to perform. The parties enter into the contract on the basis they will perform the contract. And what they provided for here is that the interests of the owner are always going to be defined by reference to getting the money out of it, getting their investment, return on their investment, which they handsomely obtain by the 48.1 notice.
I mean, I see how all this bites in relation to relief from forfeiture, but on the construction issue, as I understand your case, once the owner declares the aggregate amount, then they can do all these things.
Only if there's non-compliance.
Well, you serve a notice giving the aggregate amount of the outstanding principal and the indemnity sum.
Yes.
Supposing the charterer has been in a position to pay those sums, then plainly you can't do the other things.
Well, that's right. But that's exactly right.
But equally, on the owner's interpretation, if you paid everything, doubtless they couldn't do these things anyway.
Well, why wouldn't they be able to do those things? Because if one looks at clause 46, the provisions under clause 46 and the remedies that are identified there under owner's rights, all of them we say are dependent upon the issuing and giving of the notice and the failure on the part of the charterers to pay the amount in full. So the corollary of that is that under this arrangement, as opposed to clause 29, you unqualified. If clause 29 is unqualified, then in theory they would be entitled to possession and all the money.
I mean, just supposing, I'll shut up in a moment, but supposing the charterer has run into financial difficulties
Yes.
and can't pay an instalment, that's an event of default.
Yes.
On your case, it's then possible for the owner to declare the outstanding amount and exercise all these remedies.
Only if the charterer doesn't
Fine, but
pay.
we assume that the reason you haven't paid the instalment is you've got financial difficulties.
Well,
And the consequences then are just as disastrous for you. The fact that you can't pay one instalment means you lose the vessel.
but that's not a contractual machinery. That arises from the embarrassment of the charterer who can't pay. First of all, we don't know that the fact that there's been inability to pay, because inability to pay actually there is a slight increased largesse given in relation to inability to pay within the termination notice, as we saw. But again, on the basis that we're dealing here not with outcomes, with all the theoretical propositions that could occur in different situations. If we look at it from the perspective of parties about to enter into a contract which they're intending to perform, they don't intend to confer upon the owner the benefits of being able to take a vessel which they never managed, they never took physical possession of, they were never the de facto owners of, and which they have, when their interest is purely as money people, everything in the agreement suggests that they obtain the windfall of receiving vessels worth millions and millions of pounds more than their own legitimate interest.
But even on your construction, that's exactly what you were providing for. You were providing for circumstances in which it would be possible for the owner to reclaim the vessel in circumstances where you couldn't pay a relatively small amount and the vessel might be worth much more.
Well, we do. First of all, so another point to that. The fact is that we don't know when a notice of this like this is served. I mean, there was the question of penalty which the judge dealt with, and there's the question of relief from forfeiture, which I'll come to in a moment. But what we're saying is that the contractual mechanism didn't provide for this windfall to the claimant on our interpretation, because the interest of the owner was always in the money, and it was always about the money. So, an example that my lord gave, a relatively small sum of money leading to a catastrophic result. Well, the parties no doubt had in mind that sort of money could be raised, whether it's whether it's raised by the charter itself, or raised by someone associated with the charter, or they borrow the money somewhere else to avoid the commercial consequences of possession being taken. And that's what the parties have actually agreed to. They've agreed to create this moratorium on repossession, which affords the charterer the opportunity to pay the only thing
Just remind me where the actual moratorium takes effect from.
We read 46A1 as the requirement to give the notice.
Yes.
And
it's clearly not a requirement to give a notice.
No. But we're saying it's the only way they can unlock the remedies that then appear at 2, 3, 4, and 5.
None of those remedies arise if it is paid in the meantime.
If it's paid immediately on, yes. I mean there is. But
there's no moratorium. They all start. Well, two doesn't, because that's to go to law. So it doesn't apply here. But the other three all start unless the charterers have paid the owners the full amount.
Yes.
And that must have paid at the moment that they retake possession. 3. Require redelivery. 4.
Indeed.
And effectively. Sell, which is 5.
Yes.
But there's no specific moratorium. You're at risk. Those things may happen before you raise the money.
Those things may have to raise the money, but the reason why I put it in this way is that let's use an example. We can see that these rights are, we say, intended to be exhaustively stated in relation to what the owner can do in the event of defaults. Now, many of those defaults, as we've seen, are not financial in their effect. So, the notice we've got a notice of, we've got a termination notice in this case, which we can look at because it's an example of a termination notice used on the Courage. It's at page 340, and there are multiple reasons being given for for what constitutes the notice of default.
Page 300.
Page 340.
Yeah.
I mean, I'm just drawing attention to the fact that it's not about the money when they're serving the notice.
No.
But they're not getting their rights to take any steps towards repossession unless they specify what they need in terms of the amount that is owing to them and prospectively due to them, was getting their money out of the deal, and this is not itself the hire charges or the charter charges or anything else that is an incident of the performance of the contract. On the contrary, the payment obligation under this part of 46, which is entirely financial, the obligations there, are only triggered by the notice. So they don't accrue unless that notice is delivered. So what I say, it is in the form of, maybe moratorium isn't the best way of expressing it. But
well, I was just following up my Lord's point that even on your construction, this entirely disproportionate result can arise. It's just one more step has to be done before it does. So an event of default occurs, financial or non-financial, doesn't matter from this point of view. On your construction, a notice is then served crystallizing the amount. And the suite of remedies available
yes.
at 222
yes.
5 arise. Ignore 2 for the moment. Take 3, which is repossession. The introductory words mean that if before you repossess the money specified in the notice is paid, the right to repossess, the other side repossess, fall away.
Yes.
But suppose you don't get the money together quick enough. You
yes.
haven't got someone
yes.
who can lend this very small amount,
yes.
which no doubt you would pay a disproportionate price to get it quickly and save your vessel. And they repossess within a day or two, as they might easily be able to do. Then you're in just the same boat, aren't you?
Well
just the same position.
I
I think that's what my Lord was putting, and I've just been trying to work it out for myself.
Because, as my Lord says, you can exercise your right under 3 the very same day as serving your notice under 1.
Yes, and equally, equally at that point in time, the charterer can comply with the notice.
Well, only if they're in a position to. They might be, they might not be.
So
if it's a money one, I mean, I take your point. If it's a money one, then probably they are in financial difficulties. And although you rightly say that if you only need a few £1,000s to save a vessel worth millions, you'll probably find someone to lend it to you. But many cases won't be like that, and some will be non-financial. Anyway. And in those cases, what you're saying is there's no reason to believe you won't be able to come up with the money.
And because, if I may just interrupt, because the owners don't have any other interest other than the money, they don't care about it other than getting their money out. So,
no, I get all that. I'm just on the rather particular point about whether this disproportionate result can occur on your the answer, I think, is it can.
Well, it can, but there's two.
But in many cases, it's not very likely to, because if the problem isn't the money in the first place, you'll be able to pay it up front.
There's 2 points I make. One is that
I don't mean up front. You'll be able to pay it very quickly.
Well, there's 2 points I make. One is we're looking at it from the perspective of the parties that enter into the contract. When they're entered into the contract, they do not expect. Although they're giving a contractual right of repossession, they're also modifying that right, and they're doing so for perfectly good reasons, as we've seen. And the second point I would make is that it was suggested by His Lordship that it's really perhaps more in the area of relief from forfeiture. The point I make is this. When the parties enter into the contract, what they crave for is certainty. What they want to achieve are contractual machinery and outcomes which can be interpreted and affected and which provide certainty. They're not likely to trade the mechanisms within 46A as we understand them for something as uncertain as equitable as the right to seek equitable relief in the court.
I wonder about that. I mean, it's a major part of your case, as I understand it, that on your case on construction, that the owner's approach produces these harsh consequences.
Yes.
But if the charter party is to be interpreted, as you say it should be, and as the judge agreed, as one in which relief from forfeiture is available in principle in an appropriate case, then the harshness of the construction either disappears or is very much dissipated.
But it only arises. I mean, we present our case on relief from forfeiture as obviously a complete alternative to the construction. Because if you're right on construction, the relief from forfeiture.
The point I'm making is that there is a relationship between the 2 points.
Yeah.
The availability of relief from forfeiture has an impact in deciding whether your opponent's construction is so harsh that it couldn't possibly be what the parties meant, even if that's what the words appear to say.
Yeah, well, with respect, I say it supports my case significantly for the reasons that I've just said, which I wrote, that the parties at the time of entering into the contract have already provided a mechanism which we say, once it's understood and correctly in the way that we say is the natural meaning of these words as properly construed, the question of relief from forfeiture doesn't arise. Relief from forfeiture as a notion, as an equitable doctrine, cannot, in my submission, be any aid to construction here, because, as I've said, and I probably am saying it again, is that what parties to a commercial contract want to achieve is certainty, that they know what the contractual consequences are of taking certain steps or failing to take certain steps, and where it puts their parties' rights, what their rights are anchored in. And that's what they've done in this specified, bespoke charter party. It's not standard form. It's bespoke. It's bespoke to the specific circumstances of this case.
Can I just come back then to the consequences of your interpretation? In entering into this contract, one of the things they know could happen is that you could get into difficulties and not be in a position to make one instalment payment. So suppose that happens. You fail to make one instalment payment. That's an event of default. The owner is entitled to terminate. On your case, they can't go further until they've served the notice declaring the amount owing. And you say, well, at that point you had the chance to raise some money. Now, I've said before, well, it can all happen on the same day. But aside from that, the money you've got to raise is not the instalment. No. It's everything.
Yes, it's everything, which can operate differently at different times in the continuum of the agreement. Obviously, the extent to which there is going to be severe loss to the parties, certainly to the charterer, is when a very significant proportion of the capital is being paid.
I don't know, because you say you put up nearly half the money at the start.
Well,
so
that's true.
Is nearly half the money.
Well, that's true. But there is a difference between having to pay the current cost, the current effectively meeting and maintaining the instalments, and taking the step of declaring by notice that you're effectively doing the precursor to repossession. At which point, it may well be that the charterer has some difficulty, depending on the specific facts of the case, depending on the circumstances. But the fact is that is the only way we can read this clause, is to give the charterer that opportunity to raise the money, and that it also creates an impediment for the owner, which we say is an impediment which is insurmountable in the context of this case, because there's never been a 46A1 notice, that it is contractually restricted under the terms of the bespoke agreement from repossessing the vessel. And that's what the parties clearly intended. Now, whether there's a residual, if you like, a residual wrinkle in all this, because even in those circumstances, the charterer might avail itself to an equity of relief and forfeiture, doesn't really help us in terms of what the parties were doing when they were entering into the black and white terms of this agreement. And they required steps to be taken by the owner to enforce its owner's rights, and those steps were not taken in this case. And really, the fact that parties didn't intend there to be an immediate repossession with all the consequences that would immediately entail is also reflected, we say, not only in the manner in which clause 46A is all predicated on the notice, but we say it's also linked to F and G, F in particular, that the parties have agreed that getting the money out would be a genuine pre-estimate of what the owner has lost from the termination. The parties never contemplated that they would automatically have the rights to a ship worth 15 million US dollars, in which they've only contributed 4.5 million, and where they've also had extraction of value from the credit, from the hire charges, and from the interest. I mentioned them, but my lords, I made a note, the monthly fixed hire, the outstanding principal, which in the Courage case is defined at 4,250,000, or was advanced by the financiers, by the respondents, and the calculation of all the other financial provisions are, as I say, linked to the capital, and the variable hire is entirely a description of the liable plus the agreed margin on the outstanding principal. And those are all within the defined terms at the conclusion of this agreement. If I can take you lords through it if necessary. You have the point. So I come then to the judgment. Which begins at page 18. And the judge sets out the history in the first 6 paragraphs, and it is notable that at paragraph 4 of his judgment, the judge refers to the finance agreement that we've just looked at. And so the judge clearly had in mind and had regard to the fact that this was the provision of finance for the acquisition of the carriers. And that's the structure, that's the nature of this agreement. And that's made clear from the fact that when at paragraph 4 of the judgment he sets out the finance agreement and he refers to the actual charter hire itself, the judge actually makes it clear that the letter provided that the charter hire included a fixed element designed to cover the capital provided by Oaktree Maritime and a floating element designed to cover interest at the rate of 7.5% above 1 month LIBOR. And he also identified the fact that unlike a hire purchase, the charterers were under an obligation to purchase on the last day of the charter. So and the judge also correctly identified from the terms of the charter party at paragraph 6 that possession and control was given to the charterers who were responsible for maintenance, crewing and insuring and were obliged to purchase. At paragraph 10, the judge records the admission by the defendants that events of default had occurred, and then he identifies the 3 issues of construction, penalty, and relief from forfeiture. And then going to paragraph 16 of page 20, and this, it must be mentioned again, is consistent with the theme that we're advancing. The judge acknowledged, as was contemplated by the agreement of the 12th of July 2019, that's a reference again to the finance agreement, that the charter parties were based on BARCOM but had substantial amendments. And the amendments, you can see, related to events of default, termination and repossession, and the obligation to purchase. The judge then reproduces the terms from this agreement, which we've been through. And in the paragraph 38, he picks up the narrative at page 31 that Mr Mallah had been designated by the United States authorities on the 10th of June, and on the 11th of June, although funds representing the monies due were received into the relevant bank account in accordance with the agreement, they went into that account, but they were only credited to the account after a license had been issued by OFAC, which allowed the release. And indeed, they were paid. The number of things flow from this. One is that the point was made in the lower court, and I suppose it's relevant to relief and forfeiture, that there'd been faithful, prompt due payment, we say, by the appellants until this point in time. There was clearly a tendering of the monies which were received into the designated account, but were treated as monies that were blocked, and they only were credited after the license was provided by OFAC. The point I'm making is, I suppose, that one simply doesn't know. I mean, I'm not inviting my lords to speculate. What would have been the position had the 46A1 notice been delivered? But it's far from a foregone conclusion, and it certainly doesn't form any part of the judge's findings, that such a notice would not have been complied with. We then come to the judge's treatment of the construction issue, and that's at page 51, beginning at page 100, paragraph 130. And the judge sets out at paragraph 30 the rival interpretations. And that battleground is set in that paragraph at paragraph 130. Now, the judge comes to his conclusion that the claimant's interpretation is correct, but in my submission the judge is wrong in his understanding of clause 46 there, because he says, in my judgment the claimant's interpretation is correct. First, it respects the wording of clause 46 itself. Nothing in the clause indicates that if the charter party is terminated from an event of default, the owner is required to serve a notice in the charter under 46.1. On the contrary, it makes clear that the owner has an option to serve the notice. He's not obliged to do so. 46.2, 3, 4, and 5 state the position if the notice is served and the charter complies with it, but they do not require that notice be served. Now, that's, it must have been wrong if I'm reading it the way that I think the judge intended it to be read, because that's not right. We've seen that, first of all, explicitly, 46.2, there has to be a notice in order to use the remedy at 46.2. So the judge is plainly wrong in his understanding of the relationship between 46.1 and 46.2 in relation to certainly that remedy. And furthermore,
Sorry, just say again. You've said that we have seen that under 46.2.
If we go back to the.
I'm not sure what you mean by 46.2.
I'm terribly sorry. So the judge said it's 46A2, 46A Roman 2. The judge is wrong when he says, he's obviously right that there's an option, that it's permissive. The owner doesn't have to exercise his rights, but if he does exercise his rights, it's in accordance with 46. And 46 rights begin by Roman 1 declaring the notice, which we've been discussing, and Roman 2 is taking action to recover the full amount as mentioned in the notice. So the judge plainly is wrong to say.
It's not, it's simply identifying the amount which will be claimed in the proceedings brought to recover money.
Yes.
It doesn't depend on there having been a notice served at all, does it?
Well, I think it does.
Same point, really. What meaning do you attribute to the or at the end of 1?
So just as these are cumulative rights, just as.
Do you mean cumulative?
Well, what I mean to say is this is, yeah. If we take 46A1, the declaration by notice of a specified amount, the 46.1 makes it absolutely clear, because this is not an incident of the operation of the contract in its normal course, that that sum in 46A1 only becomes payable, due and payable, by the notice being given. And there's an obligation, by giving that notice, it triggers an obligation to pay the balance. So I'm afraid I struggle with any suggestion that 46.2 is independent of 46.1.
So let's just come back to my point. What does the or at the end of 1 do? Because you say you can't do 2,
Yes.
3, 4, or 5 unless you've done 1.
That's right.
But that's inconsistent with the fact that at the end of one it says you can do one or.
Yes. Because
So, but you say you can't.
you can't Roman 2 is a right that is a right to take action to collect the full amount.
But leave aside, don't worry about whether it's 2, 3, 4 or 5. You say you can't do any of them unless you've done one.
That's right.
So why is the or there? Because the or says you can do one or you can do something else.
Yes, but I see the tension there. I do see what my lord is identifying as the tension that that it would be easier with a conjunctive rather than a disjunctive because the and in this case the taking of the action by law. I mean
the structure. Well, you have to say two things which are related.
Yes.
One is that the use of and or is notoriously sloppy.
Yes.
On drafts, it's often used when it needn't be or shouldn't be. And really, the better structure of this would be, may at that option declare by notice da-da-da-da-da, and take all or any of the following steps.
Yes.
2 to 5. That's what you say the effect of this is.
Yes.
Not how it's drafted, but
yes.
not
And there is a guide to that because what they intended was certainly that there had to be a notice because the notice is predicated in 2 because otherwise there's no
yes,
and it's also predicated in all the others which all use the same proviso unless the charterers have paid the full amount mentioned in the notice. So there's clearly a dependence on 46A1, contrary to what the judge understood. But the use of or probably was intended by the sloppy draftsman, if I can adopt that, because the parties wanted to also say that the remedies were, in this sense, cumulative, that they could be used differently. One remedy didn't prevent the later or simultaneous exercise of another remedy, and that's expressed in...
Well, and or is perfectly appropriate, I think. I haven't looked at it carefully, but I suspect it's perfectly appropriate as between at the ends of 2, 3 and 4.
Yes.
But it's not appropriate, or at any rate,
Yeah.
it's loose at the end of 1.
I, on the contrary, I have to accept that there is a that although it says and or, no action could be taken under Roman 2 unless 1 had been complied with. So really, it is and. But in my submission, the judge is wrong, nevertheless, at 51, at paragraph 131. He's wrong to say that these steps that are in 2, 3, 4, and 5 can be taken, but don't require that the notice be served. And he's wrong, therefore, to say, because he fastens on the and or, that means that the remedies are independent of each other. They're not independent of each other because they're all predicated on the use of the notice. Now he did.
Hang on 1 second. Yes, thank you. I just was checking something. Yeah. Yes.
Yes, and it follows that we say that the judge is wrong at paragraph 132 of his judgment. because at paragraph 132 of his judgment,
Well, just before we, he says at the end of 131, clause 46D confirms this.
yes,
That's true up to a point, but he refers to them as the remedies in the subclauses are independent of each other.
yes, and
And the remedies are 2 to 5, as
Yes.
he describes them.
yes,
Yes, one isn't a remedy, is it?
no. One is a step, a necessary step. It triggers. It's a step that has a contractual effect because it triggers an obligation to pay.
I suppose you could call it a remedy.
Yeah.
Anyway, yes, thank you.
So, but I was at paragraph 132, and I say that here, again, I say the judge is wrong in saying, because he doesn't actually, in my submission, explain why the words, unless the charter to pay the full amount mentioned in clause 46A1, is not regulating the exercise of the remedy. It has to regulate the exercise of the remedy, because first of all, it's the obligation to pay that sum is not rising under the operation of the contract. It's not arrears, for example. It's not arrears. It's not default interest. It's a sum to buy out the interest of the owner, and the defendants or the charterer neither knows that amount until it's specified, nor is he under any obligation to pay it until the notice has been delivered. So, Judge may say he's not persuaded by the argument, but in my submission, the argument advanced before him was overwhelming.
See, really, well, the judge's construction, yes, there are effectively two scenarios. One where the notice is served,
Yes.
which will be done where the owner would like to have the money.
Yes. I go one step further.
But obviously also wants the other remedies
Yes.
if he doesn't get the money, or where it's not served, where he doesn't particularly want the money, and or doesn't want the money full stop, would rather have the other remedies, so it doesn't give you the opportunity to serve the money, send the money.
But he hasn't got the other remedies. Our point is that he
Well,
doesn't.
no, but I'm just trying to see what the judge is. That's how it works. Why isn't that commercially a sensible outcome from the owner's point of view? He can have remedies, but give you the option to pay him off quickly, or remedies without giving you the option to pay him off quickly.
So we say that as a matter of purely the interpretation of the remedies clause, of the owner's rights clause, he doesn't have a freestanding independent right to do those things in 3, 4, and 5. He doesn't have those rights until he's gone through the precursor right of serving the notice. And that's what the parties intended, for good reason, for the reasons that I've already adumbrated.
Yes.
But when the judge is looking at this as a point of view, if he was looking at it, through the prism of Woods and Capita, using the canons of construction, I mean, I'm not criticising the judge for not setting out in a case which was all about construction the sort of headline cases on construction, because you'll know that those were very well known to him. I'm not suggesting he would, but one cannot see within this analysis the approach that the courts have been adopting now for some years.
What happens on your case if the owners terminate the charter party,
Yes.
they're entitled to do,
Yes.
but they choose not to serve a clause 46A1 notice? And clause 46A1 makes it
Yes.
quite clear they don't have to serve one.
Yes.
You say then, do you, that the owners cannot get possession of the vessel, but the charter party has ended, with the charterers remaining in possession and under no obligation to pay hire? Can't be under any obligation to pay hire because the charter's come to an end.
So there's two things about that. First of all, there are certain obligations which the parties preserved during that period of bailment. We saw that, like ensuring.
Yes.
There were certain residual. I mean, again, it's consistent with my reading of the case, and so I took you to that.
Those are all to maintain the value of the owner's asset.
Well,
But it's an asset they can't get possession of.
well, no, because they're if the charter party, if the position is that they've terminated the charter, then they have the means of extracting their interest through the remedies that we've been looking at, which gets them out of the scene. They can go back to investing in other things. They've got their return, they've got the money, and they've even got indemnities in relation to any other losses. So they've covered all that, because ultimately all that the vessel was ever doing was providing security.
Well, no, you say they can get all that if they serve a notice, but I'm asking you what happens if they choose not to serve a notice?
Yes.
And is your case what I suggested to you, or is it something else?
Well, it wouldn't be commercially sensible for them in those circumstances not to serve the notice. After all, the notice can be served by delivery to an address.
No, I'm sorry, but saying that it's not sensible for them not to serve a notice doesn't answer the question. What happens if they choose not to do so?
Yes. Then in principle, the following things emerge. The relationship between the parties is no longer that under the charter. What you replace it with is a bailment. That bailment is not entirely gratuitous because the parties have agreed certain obligations on the part of the bailee, and although there's no right to the hire, there's I suppose, and it's not something that which is why I say it's not commercially sensible, because their rate of return is much better under the charter party to get their money back. But whether they would bring a claim in quantum mirate, I don't know. We're in the realm there of supposition of whether or not there'd be any duty on the part of the on behalf following the termination, whether there'd be any duty. Because what we're concerned with here is specifically rights to repossess.
Just picking up one point, you say, well, it would obviously be in the owner's commercial interest to serve the notice. I mean, the judge did have a point on this. He says at the end of 138, well, the owner might not be in a position to serve a notice.
I don't understand that, because the notice is given by, I think, at the specified address within the.
But no, I don't think that's his point. Sorry. End of 138. What he's saying is, when you serve your notice under 46A1, you declare the outstanding principal and the indemnity sum. And the indemnity sum is tied to, is it clause 38?
Yes.
And he's saying, well, at this point, the owner may not know what the indemnity sum is.
Well, there's obviously a separate question there, which is how the indemnity sum in the notice is calculated, because the notice is given. Let me just come to that. Yes. So 237 is where we have the indemnity sum definition. The indemnity sum is any outstanding indemnity payments payable by the Charter pursuant to Clause 38 or any other provisions of this Charter. And Clause 38 is the obligation to keep indemnified and you'll see that you're indemnifying them against that which is claimed or assessed against what I'm looking for really is that the So, first of all, one's got to look at it from the perspective of the parties entering into the contract. There can be all sorts of individual circumstances that could arise, but the parties clearly had in mind that at the point at which the owner is getting out of the contract and taking its money, that it can demand the indemnity, and provided it did so in a manner that wasn't elusive, but was a demand for indemnity within the notice, it would be an effective notice. So, and indeed, the rights to indemnity even survives that, because we've seen that it can. Even subsequently, that if they can produce, they can claim further indemnity, I suspect, if they didn't specify it in the indemnity notice. So it's a fair, in my submission, they've held the ring between the competing interests well within Clause 46 in prescribing and limiting what would otherwise be untrammeled rights on the part of the owner to deprive the Charter of everything it has.
At one point I thought you were saying that it would always be in the owner's commercial interest to take the money, subject to my lord's point about, or the judge's point about whether he was in a position to calculate it. But what about paragraph 139 of the judgment? Circumstances of the present case might be one, but others can be thought of, where it would not be in the owner's interest to take the money.
Well, I don't accept that, because I'm talking about the owner's real interest, the legitimate interest, the interest that the parties had in mind when they entered into this agreement. And we've seen from both the surrounding circumstances, from the finance agreement, from everything we know after the due diligence that was carried out by the owners when they... It wasn't the case that they entered into a transaction of this nature. The evidence was, I think, in the lower court that they carried out diligence prior to doing this. So the risks of various things happening and all these types of trying to construe the agreement by reference to what has happened subsequently, in my submission, don't really provide us with a suitable guide to the interpretation of the agreement. The parties, where the judge says that it might be advantageous to take the vessel rather than take the money. Well, first of all, the question is that that's not what the parties had in mind. That wasn't the mechanism, and in my submission, it's unthinkable. It was unthinkable when they entered into the contract, and it's unthinkable now. that the claimants could get their money and get the vessel. They would be getting, in the case of these ships, I mean, just the
So
scale.
that's not what the judge is saying. He's saying get the vessel instead of their money.
Yes, but if that was the case, well, why would they not take the money?
Well, one reason that I think your only answer to this given is, well, nobody could have had this in mind, was that it might be as effectively tainted money. You might get yourself into difficulty with the sanctions enforcing regimes if you take money from someone who is under such a regime.
So you can say that about almost every commercial contract. You do the diligence on the person that you're contracting with. You can't say that the performance of an obligation which involves money should not.
It's implicit in what you're saying that you accept that there might well be risks in taking the money rather than simply securing and selling your ship. In the events which have happened because of the notice on Mr Mallah.
But if one looks at it from the perspective of the contract being entered into, they put it this way: if let's say the respondents were to put this argument to the judge, without business concerning Mr Mallah and sanctions, we want to take the ship because the ship is a much more valuable asset to us than the money.
Yeah.
If they said,
well, that isn't the point.
Well, it would be because that's what the parties are contemplating when they're entering into the contract. They're saying, do we intend that in the event of termination for any form of breach based upon any one of the many potential events of default, that the owners will be entitled, despite the structure and mechanism of this agreement and all the things I've already taken you to capture the value of the vessel. Well, what they've done is they've spelled out everything in the 46A. We've seen that it can all be converted into money. Unlike any commercial contract, you can't say, well, because subsequently one party becomes tainted or the money's tainted. The way to deal with that, as I say, is not as a matter of contractual construction, it's to be careful who you do business with.
Well, the other way of looking at it might be that the party's view, no doubt probably the owner's view, because they may have been commercially in the stronger position, was we want options. You may well be right that normally to follow the notice procedure will be the best procedure.
Yes.
Because we have our cake and eat it.
Yes.
If they can come up with the money, then we don't need to take any of the other remedies. And if they don't, we can proceed.
Yes.
But we would also like the opportunity not to go down that route because there might be difficulties in the earlier point we were discussing, identifying the sum due, or the sum that should go on the notice. There might be delays in having to calculate it and serve it, and we may need to move very fast. Or, even though it's unlikely they thought of this particular state of affairs, but you never know, we might not be able to take the money for the sorts of reasons we've been looking at. So we'll keep that option as well. That seems to me a commercially sensible outcome. Not good for you, but it's a commercially sensible outcome.
That's only a commercial. We're going to talk about outcome if we first look at what's the language. We're at the moment concerned with contractual construction. And if I'm right about this interpretation, which we say is the most natural and obvious meaning of the words that the parties have chosen to use, then the express terms of the clause require the notice be given. And it cuts down the rights to repossess.
Well, there's two separate questions. There's a question about actually how we construe it verbally, and we've been looking at that, and I think you made your submissions on that.
Yes.
But you say you pray and aid not only the technical verbal analysis, but also what would be commercial common sense.
Yes.
And it was on that last point I was addressing.
Yes. So I say that bearing in mind that there is a balance that has been struck here between the fact that certain rights may be exercised, don't have to be exercised, there are options available to the owner. Those options are the ones prescribed in the agreement by the language that they've chosen to use. The idea that without the telescope of hindsight, the parties have in mind that there could be circumstances in which enlarged rights would be better for the owner, which are not merely opportunistic and intended to derive windfall. My submission, it's not going to assist on the question of the commercial purposes and what, objectively speaking, would be regarded by the reasonable person as being the meaning of the contract. If one just uses.
Mr. Barclay, I just need to remind you of the time. We're on the construction point.
Yes.
We might not hold you to literally lunchtime, but you've still got the relief and forfeiture point
That's
to go.
true.
And I'm not sure you've totally finished.
Yeah.
You haven't challenged every bit of the judge's reasoning on the construction argument.
I'm working my way through the judgment.
Sorry?
I'm still working my way through the judgment.
Yes, but until now, when we got to the heart of it, we've been very. You can't complain. You've had a lot of interruptions from the court, so I think you've got to just plan your time a bit. Yeah.
So, I'd come, I think, to paragraph 134 of the judgment, where the judge identifies the variations and deals with the issue of whether 46 adds a gloss to clause 29. Now, this was important because, as I understand it from my learned friend, Miss Wilmot Smith, what was accepted was that the way in which 46 and 29 was to be read in conjunction on the claimant's case was that 46 added a gloss to 29, in that as the owners, they might choose to serve the notice. And so potentially, if the charter paid in accordance with it, they would thereby waive their right to repossess. So it's not clear how that works on the claimant's case, and no doubt my friend may develop it. But what I say is that what that acknowledges as a matter of contractual interpretation is that it was never the intention of the parties that they'd get their cake and eat it. Getting their cake and eating it was never something that was in the contemplation of these parties when they entered into this contract. And in paragraph 135, the judge introduces something else which with respect, is open to contention. The judge says, on the other hand, the defendants' interpretation is, to my mind, inconsistent with clause 29, in that the right to possession for which 29 provides in unqualified terms would be reduced to a wholly contingent right. That's not correct. We already looked at clause 51, which means that one's got to read clause 29 with clause 46. They're not incompatible. The effect is that when you read them together, the 46.1a provides a contractual obligation, a contractual requirement, machinery, which fetters the rights of possession. That's nothing to do with contingent rights. I don't accept that it reduces the claimant, in this case the respondent, to having something which is said to be a wholly contingent right. I mean, the judge uses the word wholly as an emphasizer, but it doesn't mean anything. What does it mean wholly contingent? There is, in my submission, no disharmony between reading clause 46 and 29 together. At paragraph 136, the judge rightly points out that the appellants below emphasize the underlying purpose, and I think that that he correctly states that. And he records the fact that that it was being said by my predecessor in the court below that would not make commercial sense. When the judge rejects that at paragraph 137, in my submission, he doesn't deal with it adequately. He doesn't deal with this point of approaching this as a matter of construction. He says, I'm not persuaded by the argument. Even on the defendant's interpretation, the charterers would face major consequences as a result of any event of default, however minor, in that, subject to relief and fortune, they would lose possession of the vessels unless they were able immediately to provide the full finance for them. Well, I've already answered that in the course of argument. It doesn't, in my submission, go anywhere in terms of what the parties must be considered or intended. More importantly, the judge says, whilst the purpose of the arrangement was to provide finance for the purchase of the vessels, the parties chose to give effect to that purpose. By
you don't need to read all this out. We can see it. What's the point?
Well, this is an important. This next point is an important one, because in my submission, the case in relation to commercial sense was overwhelming. The judge needed to deal with it, and he doesn't deal with it effectively for this reason. First of all, because he seems to suggest, as we discussed earlier in the course of argument, that somehow or other finding the money is an impediment to the interests of the appellants, which I've already made my submissions in relation to that. But more importantly, the judge doesn't challenge the fact. In fact, he adopts the point that the purpose of the arrangement was to provide finance. He adopts that. But then he doesn't deal with it, because he says that parties chose to give effect to that purpose by arrangements, and the consequences of the claimant's interpretation are not commercially remarkable in the context of a, notice the indefinite article, chartering arrangement. That might be so. That's not what he had to consider. He's wrong there in his approach. He's wrong in principle, because it's not about, in abstract, whether it's commercially remarkable in the context of a chartering arrangement. What it is in relation to this arrangement between these parties, given the particular matrix that was being urged upon him, whether in those circumstances, between the two rival contentions, the appellant's interpretation made more commercial sense. And in my submission, the judge can't say in that final sentence there, the court is not entitled to disregard the structure of the arrangements on which the parties agreed because it considers the underlying purpose of it might have been structured differently. That's not our point. We're not inviting the court to rewrite the contract. That's not any part of the respondent's case. What we're saying is that the judge here, at this point in the exercise, should be asking himself, what is the meaning and effect of the words that the parties have chosen to use? And what are the contractual consequences that flow from that? Rather than saying, well, a standard form chartering arrangement might not contain these special provisions. Well, we know that because in this case, the parties didn't use a standard form, as the judge acknowledged. And in this case, the parties agreed that the rider clauses, which is where we find the meat of this sandwich, would prevail over the standard clauses. So, in my submission, the judge has simply not faced up.
And we've got your point now.
Yeah.
And we've got your point. So I don't want to hurry you for our sake. I'm hurrying you for your sake. You've dealt with 138 and 139.
Yes. Yes, we have. So, before if I could just excuse my back, my Lord, because I'll try to move on to at least deal with.
You.
I just want to deal, if I may, with what I take from part of the judgment in relation to penalties. Yes. So the judge had to deal with the submission that the effect of the loss of the rights to purchase were penal in effect and constituted a penalty, that brought in consideration of the Court of Appeal, of the Supreme Court's decision in Makadisi. In paragraph 148 of his judgment, which I accept is obiter, the judge finds that there is no penalty. When dealing with the competing arguments about disproportionate detriment as against the legitimate interest of the owners in enforcing the primary obligations, the judge stated at paragraph 148 that he considered that the appellants had the more powerful argument. And he appears to set out with approval the 3 points in the 3 points in the submissions made by Mr. Dunning, who then appeared for the appellants. And in my submission, each of those 3 points should have been part of the iterative process when seeking to construe the language of the clause. I won't go over it again, but the point I'm making is that simply to fall back, as the judge did, on saying the structure it's a form of charter and we can't look behind it. Well, the fact is that the judge should have, in my submission, considered the very same considerations that he gave to the issue of penalty at paragraph 148 when seeking to deal with the construction My Lord, I'm going to go on now to deal with relief from forfeiture.
Yes.
And as I think I've made clear, this is very much a second string and very much an alternative. If we're right on the interpretation point, then it certainly doesn't arise. I, first of all, have to accept, and I do, that the judge made certain findings.
Yeah. Yes, I don't want you to think you've got to deal with it all in 10 minutes.
No. Well, I don't know whether this...
Mr. Barkley, the person going first does take a bit longer because they're introducing us to the materials, but you won't have much of the afternoon, so bear that in mind.
I anticipate that the points I'm going to make on relief from forfeiture are likely to be...
Good, good. I just didn't want you to feel under such time pressure that you didn't do yourself justice. Yep.
My Lord, the judge's findings in relation to issues of misconduct or impropriety in relation to the appellants themselves features in the judgment and clearly influenced him on the question of relief from forfeiture. And in particular, what seems to have been very much what the judge was influenced by was that the case being advanced by the appellants, that Mr Mallah had divested himself of his interest in the companies, was an attempt deliberately to mislead the court.
Sorry, you're talking very quietly.
Was an attempt, yes, that the advancement by the appellants of a case to the effect that Mr Mallah had divested himself of his interest in the companies was an attempt deliberately to mislead the court. And the judge clearly focused on that in, for example, in paragraph 165 of his judgment, and the findings by the judge that in relation to both control and the conduct have not been directly challenged. The issue of relief from forfeiture, once the judge had found that there was a right that could be exercised of relief from forfeiture, because the judge at paragraph 156 correctly took into account the observations of Mr. Justice Cook in Jotunheim, that relief from forfeiture was available for these purposes. In the context, that was a bareboat charter. And so this was potentially a discretionary equitable remedy which the judge in the event refused to grant. What we say is that the judge should have been looking at it from two different perspectives. One was to identify what the rights were, what was the equity being sued for, in this case on the counterclaim relief from forfeiture. And the second was the question of misconduct which could lead to the applicant, the appellants in this case, being regarded as having unclean hands. Had the judge approached it in that two-stage fashion, what the judge would have come to as a conclusion, we say, is that there were overwhelming countervailing arguments in favour of the grant of relief. But this wasn't a case on the margins, that if I'm wrong on the interpretation point, then we can see that there is an enormous loss to the respondents who have faithfully till then made the payments under the agreement, that it confers a wholly disproportionate windfall benefit onto the respondents.
Well, the judge expressly said he wasn't prepared to make that finding in relation to the courage.
Yes, and there wasn't. It's difficult to see why, in relation to the courage, because the courage hadn't been inspected, as I understand it, and because
because you'd stopped the being inspected.
Yeah, well, I understand that, but the evidence, although the courage had not been inspected, in relation to the courage, what is empirically the case is that the appellants had paid just under $4 million US, $3,938,186 as repayments under the fixed hire charges, and the amount outstanding, which represented the interest of the respondents, was only $885,416. So they're getting a ship, which it's true that there may have been difficulties about inspection, and one can take a view about various things, but I wasn't at the trial, but my understanding was that desktop valuations, which was all that were in play at the time, that the evidence was that the market value, based upon desktop valuations, not based upon current condition because of the absence of inspection, put the vessel between 11.55 million and 15 million. So it's staggering. It's absolutely staggering the value that's being returned to the respondent. And whilst I accept that there may be a question about unclean hands and so forth, but in my submission, the judge should have dealt with it in this two-stage manner. He should first of all have looked at, well, is relief available, and what is, not just saying is relief available jurisprudentially, but what are the countervailing benefits and detriments?
Sorry, I haven't identified what the two stages are. Just in a word, couple of words, what are the two stages?
So what the judge should have done was should have first of all identified what the appellants would lose, what their history had been in terms of performance of the contract up to that point, and what, in this case, the respondents would stand to gain, which was out of proportion.
What's the second stage?
The second stage is has the appellant, by his conduct, deprived himself of the ability to get that equity.
So the first stage is identify the respective balance of advantage, disadvantage.
Yes.
And second, what's the second stage?
Second thing, then the second is there, are we prevented from giving that relief to this particular applicant because of the applicant's unclean hands? Because
is the applicant's conduct sufficient to disentitle them?
Yes, or to place conditions, for example. I mean, there's all sorts of ways in which you deal with unclean hands.
Sorry, I just wanted to understand what the two stages are. I've understood it.
What I say is that is also consistent with authority, that the court should do it in two stages.
The judge did cover both stages, didn't he? He covered them in the other order, but does that make a...
Well, yeah, it doesn't. In my submission, he doesn't deal with it. First of all, the judge, had he done the exercise in the manner that I submit is the appropriate manner, then he would have identified first of all the countervailing equities and the principles. He would have seen this was not a case on the margins. He would have come to conclusions very similar to the conclusions he reached on the penalty issue, that it was going to confer a disproportionate benefit on the respondents, and that the claimant would lose its valuable asset, when it was effectively saying it wanted the opportunity to continue under the charter arrangements and effectively regularise that, which is what relief of forfeiture is all about. The judge should have done that and then considered the second stage, which is what is the misconduct that could operate as unclean hands, and to what extent, first of all, does that misconduct, to what extent is it immediately or necessarily related to the equity that is being sought? And secondly, how does he achieve it? Because relief of forfeiture isn't a binary matter. It's not just I grant it or don't grant it. It'd be granted on terms.
Yeah. Now it's just past 1.
Yes.
We'll sit again at 2, and you will perhaps use part of your lunch just to make sure you can make your submissions on relief in as economical a manner as possible.
Well, my lord, yes, I will endeavour. As I said, I don't anticipate that I'm going to be a protracted period of time over the relief and forfeiture. I just want to make sure that I make my points to this alternative.
Yeah, of course. Yes, thank you very much.